Hello and welcome to this talk on bringing a claim for judicial review. I'm going to talk about interim applications, but I won't be dealing with removal claims. My name's Declan O'Dempsey, and in this talk we're going to be looking in a little more detail at interim applications. The first question is whether it's appropriate to seek an interim remedy, one of these interim applications. An interim remedy is a remedy that applies while the case is pending. And for example, it would include an interim order stopping any action that the defendant plans, or an order requiring the defendant to act in a certain way. Normally you will make a request for an interim remedy on the claim form, but you can make it at any stage of the proceedings, and exceptionally you can make the application before proceedings have started. If you're going to be making an application for an interim remedy, it would be wise to look at and at least read the Civil Procedure Rules, parts 23, 25, as well as of course part 54 dealing with judicial review. The court will require you to give an undertaking in damages as a condition of issuing an order, one of these interim orders. Now, this is an undertaking that if the defendant successfully defends the claim at the merits hearing, or ultimately, but has suffered financial loss because of the interim relief order you obtained, then you undertake to compensate the defendant for the loss they suffered during the period that the order was in force. It's important to realise that giving an undertaking is a big step. This is because an undertaking is treated as if it's an order of the court in many respects. In particular, breach of an undertaking is equivalent to breach of a court order, so that the court can impose sanctions. And these sanctions will include adverse costs orders made against the defaulting party. The court can simply refuse to hear your application as a sanction. It can strike out the claim, and it can also proceed to consider whether to commit you to prison for contempt of court. So giving an undertaking is a very serious matter indeed, and can have serious consequences if you fail to honour it. If you're making an application for an interim remedy, such as an injunction, you'll be able to make the application in Section 8 of the claim form. However, sometimes you will need to give the substance of your application, the reasons for the application for the interim remedy, in a separate document. So what you do then is you refer to the separate document in the claim form. So on the claim form you'd say, I'm applying for an interim injunction. Please see the grounds on my application, which are contained in a separate document, and then you identify that separate document. The process of decision making in relation to an interim application is generally this. The judge will first consider whether or not to grant the application by considering what you've written and the evidence that's put before them. So this is known as considering the case on the papers. It's normally dealt with at the same time as the paper application for permission to apply for judicial review, when again, of course, the judge is looking at the documents that you have supplied and deciding whether on the basis of those documents there's any basis before giving permission to proceed for a judicial review. The point of doing it in this way is that it reduces the amount of paperwork that the court and all the parties have to deal with, and it also reduces the amount of time that the court has to spend on your case. It also has the advantage, if you do it in this way by applying on the claim form, that it doesn't require an additional fee, whereas if you do it later on or separately, then you'll need to pay an application fee. If it's not dealt with on the papers, then there will be an oral hearing, and indeed the judge considering the application for the interim relief order, who may be deciding it alongside the permission application, might make an order based on the papers, but they can also make an order that the application for interim relief should be dealt with at a hearing in court, and very often that will be the same hearing as will deal with your permission application. There's a separate procedure for cases requiring urgent consideration, and I shall deal with that in a later talk. In exceptionally urgent circumstances, you can apply for interim relief before you've even started proceedings. And again, I'll talk about that in a little more detail in a later talk. Let's suppose, however, that you're in the middle of proceedings and it becomes apparent that you need to obtain an order, say an injunction. Well, then you're going to have to issue an application, and you'll need to use form N244 or PF244. Now, you can find those on the court's website. If your application is urgent, it's necessary to make that clear in the application form. You should indicate the timescale within which the judge is requested to consider the application, and you should put that in the application form itself. And the Administrative Court Office Guide to Bringing a Claim for Judicial Review advises that it's preferable for you to also put that timescale within a covering letter. The point is, you need to do something to make sure that the urgency of the timescale for consideration is brought to the attention of the court office, so that it can then speed things up for you and make sure that the judge who has to deal with these applications is aware that there is a particular urgency suggested in relation to your application. In a later talk, I will deal with urgent applications generally, but for the moment I'll say this: be very cautious about claiming that your application is urgent when in fact it isn't really urgent. This is because the courts have noticed that people tend to try and push themselves to the front of the queue for consideration by alleging that they have an urgent application, and experience has shown that not everybody who says they have an urgent application actually has an urgent application, and there is accordingly a reaction to that by the court. Whether or not your claim is urgent, you should always serve your application on the other parties in the case. You're not obliged to do that if it's impracticable, but the court will need a lot of convincing that it is in fact impracticable to serve your application on the other parties. And the court's unlikely to consider your application unless the other parties have been given the opportunity to respond to your application in writing. If you've been refused in your application without an oral hearing, you can request reconsideration of that decision by lodging an application form an application notice rather, on form N244 or PF244, you'll need to pay the relevant fee, and you must serve the application on all the other parties. If you've been refused on the papers, then reconsideration will take place at an oral hearing in court. If you need that reconsideration of your application to be within a set time period, you need to make that time scale clear in the application, and once again, the advice of the Administrative Court Office is that it is preferable for you also to make that time scale clear in a covering letter alongside the application form. There is a process for extremely urgent cases which is not available to litigants in person. If an application cannot wait until the court's sitting hours, then the application for reconsideration can be made out of hours to the out of hours or duty judge. A practitioner who makes this application will be asked to undertake to pay the relevant fee on the next working day. Because this service is not available to litigants in person, it's a case in which you need to think about whether you should use a solicitor or a barrister working under the public access scheme for that kind of extremely urgent work. It may be a question of whether or not you can afford to do that, and also you really do need to think about whether you need to make the application overnight or outside court working hours. But it is the kind of situation in which it may be worth having a barrister or solicitor, if only for that part of the work. If you want to challenge a decision which was made on the papers, you have to apply for reconsideration in the administrative court before you can appeal. So always seek reconsideration first before trying to appeal. I want to say something about the criteria on the basis of which interim relief is granted. It's important to bear in mind that you need to make a strong case in relation to these issues. This is because in judicial review cases there is considered to be a strong public interest in allowing a public authority's decision to continue to have effect until it's reviewed by the court. So if you want the court to prevent that from happening, even on an interim basis, you will need to make out a strong case for relief to be given to you in advance of the substantive or merits hearing. So what the court will ask itself, and what you will need to address in your application for relief, and you might want to put headings to this effect in, are the following questions. Is there a real issue to be tried? Now, what is meant by that formulation is that there must be a real prospect of your succeeding at the substantive hearing. This is a very difficult thing to judge for somebody who's bringing their own case. What the case law says is that it means that there must be a more than fanciful prospect of success. So it's one of those situations in which you need to be careful about your desire to achieve a particular result, reinforcing your thoughts about how likely it is that you'll achieve that result. So the wish can sometimes be the father to the thought, is I think the saying. Well, you need to try and check yourself from thinking that your claim has prospects of success when in fact it's got just fanciful prospects of success. And if you know anybody who can listen to you about this and who can give you a reality check, then it may be well worth talking to them about it to try and get some kind of objectivity on your prospects of success. But this is very difficult stuff, and the courts are aware of that if you're trying to represent yourself. The second question that the court will ask itself is a rather odd-looking question, particularly if you're bringing a claim. And it's this: does the balance of convenience lie in granting the interim order? Now, the concept of the balance of convenience is, again, not a straightforward matter. In another talk, I've dealt with the balance of convenience when a court is dealing with whether or not to grant an injunction. So if you want to go into more detail on this, then have a look at the talk that I've done relating to injunctions. But essentially, the court will ask itself whether it should maintain the status quo, so the situation before the application was made, and it will ask itself how making the order will affect things, how not making the order will affect things, and it will try to see where the balance falls for it. It's important, thirdly, to remember that the interim relief you're seeking is a matter which lies within the court's discretion. So the court has a discretion whether or not to grant relief, and it will consider any other factors that it considers to be relevant. So the behaviour that you've exhibited in the process of bringing your claim to the court may be a relevant factor, and equally the behaviour of the defendant. But the court will consider any other factor that it considers to be relevant to the question of whether it should exercise its discretion in your favour. One of the great temptations, I think, for a litigant in person who is very eager to obtain an order is the temptation to try and get the thing to the court regardless of whether you've had a response from the defendant. It's really important to remember then that the defendant's response to your application will mostly be regarded as necessary by the court, so that the court is likely, if time permits, to permit a defendant to have an opportunity to respond to your application. Now, if there is an urgency, it may be prepared to abridge or shorten the defendant's time for the service of the acknowledgement of service, or it may decide that the application and, for example, the permission hearing should be called in for a hearing on short notice. So your application for interim relief may be separated out and you may be called in for a hearing on that at short notice. If the time doesn't permit an immediate response by the defendant, the court may grant you relief, but do so for a very short period until the defendant has been able to make representations, whether in writing or at a hearing. So you might get an order, but it would be stipulated that it only lasts until there's a possibility of the defendant and yourself either being in front of the judge or for the defendant having an opportunity to make written submissions as to its response. In certain situations, the merits of your claim will be considered to be unclear, and it may be that there's no particular urgency on your case. And in those circumstances, the court may give directions for a speedy or expedited determination of various aspects of the case. So they may say it's necessary to have an expedited determination of permission, or the court may order an expedited or speedy trial of your claim. This might be on the basis that we talked about in an earlier talk, that the permission aspect of your case should be rolled up with the substantive hearing. So that's when the court will look at the question of whether you should get permission, and then if you do get permission, immediately go into the merits hearing. Or indeed, it may simply say, well, tell me all about the merits of the case, and I'll hear from the other side. And then right at the end, it'll make a decision on whether or not permission is granted, effectively at the same time as saying whether or not the substance of the case goes in your favour or not. And so, for example, at that stage, you might get knocked out because you don't get permission, or you might get permission, and so the court accepts it's an arguable case, but then immediately goes on to say, but we find that on the merits the case goes against the claimant, or indeed it might accept that you win. So the court will try, in relation to these expedited or speedy hearings, to ensure that both parties have had a chance to argue before the court all of their points before any form of order, whether granting or refusing relief, is made.